In today's video podcast, I want to address this interesting question. When do notices require seller signature? I know that is a funny question until you put it into context. This weekend, I was asked about a sale of other property contingency and notice of the waiver of the contingency. The question was when a buyer gives notice of the waiver of the contingency after seller notifies buyer that he accepted a backup offer, does the seller have to sign off acknowledging that the primary contract is still in effect? As to another notice, like written notice, that a buyer was unable to get buyer approval, or notice that lender did not approve the property, which has to be accompanied, of course, by a copy of the statement of denial from the lender, does the seller have to sign off acknowledging that notice and termination of the contract? The answer to the question depends on what the notice is doing. If the notice is just for a party to waive a right to something they otherwise have, then that notice does not need the other party's acknowledgement. The party can waive that notice, and that decision is a unilateral decision. But if the notice is to inform a party that something did not happen, which then affects the obligations of the parties under the contract, then the other party has to agree that that reason exists. What is claimed as not happening does in fact have to be agreed to by the parties. As explained in previous video podcasts, if a reason has to exist for the parties to terminate their obligations under the contract, then before the contract will be deemed terminated by the title company, both parties are going to have to agree that that reason does in fact exist. It's confusing to some because the contract is clear that, for example, upon notice from buyer to seller under buyer approval, if the buyer gives notice they didn't get approval, the contract terminates and the earnest money is refunded to buyer, as the contract states. The notice is that buyer was not unable to obtain buyer approval. However, the contract calls for the buyer to apply promptly and make reasonable effort to obtain financing, including furnishing all documents required by lender. Failure to do that means buyer cannot terminate using that reason. If a reason has to exist to affect the obligations of the parties under the contract, the notice is required but is not sufficient to terminate a contract without both parties' agreement. With regard to the first scenario, a buyer gave notice to seller of waiver of contingency. That notice was sufficient without further signature from seller to continue the contract. However, the waiver required notice and deposit of additional earnest money. The notice was timely, but the money was not yet deposited. Is that a problem? In this particular scenario, the day to provide notice of waiver occurred on a Saturday. Because deposit to escrow agent was not possible until Monday, the buyer's notice and deposit on next business day is sufficient to maintain primary position. I hope this video podcast is helpful, and I hope to see you at the Allegiance closing table soon. Thank you.